The following program is a production of Stetson University College of Law.
Good day. I'm Professor Charlie Rose, and this is Practice Ready Evidence. Good day. I'm Professor Charlie Rose, and I want to talk with you in this block of instruction about Article 2 of the Federal Rules of Evidence, the rule that deals with judicial notice. Now, judicial notice is a concept that sometimes gets a lot of attention in evidence class, but usually not. It's a very practical rule, and it works like this. If I, as a litigant, have a fact that is generally accepted in my particular jurisdiction, that is known to be true and it's not going to be controverted, I can request the court, or the court can move sua sponte, to notice this fact and to instruct the jury that has noticed this fact. Now, this works particularly in civil cases to remove that fact from being an issue at trial. Now, what do I mean by that? If the court takes judicial notice of a fact in a civil proceeding, unless evidence is presented to rebut that judicial fact, they will be instructed that that fact has been proven as it pertains to the cause of the action. So it has power, particularly in a civil proceeding, to narrow down the case to the issues that are in controversy. Now, in a criminal proceeding, judicial notice has the effect of establishing that the court believes that it's so, but the jury has the ability to disregard what the court has decided. There are some interesting things about judicial facts judicial notice, in that some are advisory, they're not required, but they're suggested, and others should be taken. And as you're looking at requesting judicial notice from the judge, you want to look at issues that are specifically factually identifiable and really not open to controversy. So as we're looking at judicial notice and the rule, you want to consider it like this. Something like the way in which the tide comes in, the tide tables, the time the sun goes up, the time the sun goes down. Those sorts of items are generally acceptable for judicial notice unless there's an issue as to their validity. The court would take judicial notice when requested by counsel. If the other counsel opposes judicial notice of that particular fact, the rule requires that the court give them an opportunity to be heard. The purpose of judicial notice is to clear away those factual issues that are really not in controversy in the case, allowing us to focus on the thing that the jury is there to decide. It works very well in civil cases, because in a civil case, if you'll think of the process of filing the suit, interrogatories, answers, additional questions, and discovery, that's all designed to get rid of facts that are not in controversy. And judicial notice is just another way to do that. In the criminal case, however, where the government bears the burden of responsibility of proving each and every element of offense to the beyond a reasonable doubt standard, judicial notice is more problematic. And in a criminal case, judicial notice may be taken, but the jury has the ability to disregard it. And where judges can get in trouble is that they'll take a judicial notice of a fact in a criminal case, and then when they instruct the jury, they will instruct in a way to say that that fact creates a presumption that removes the necessity of the government from proving that particular element of the offense. That is unconstitutional, and there's case law that's saying it's so. So, as advocates, looking at the use of the Federal Rule of Evidence 201 for judicial notice, what do I suggest that you do? Well, first of all, identify whether you're in a criminal or a civil proceeding. Secondly, look at the nature of the fact that either you or opposing counsel want to ask the court to take judicial notice of. And if I look at the nature of that fact and I determine that it doesn't hurt the theme and theory of my case for the jury to be instructed by the judge on that issue, well, then I don't object. If, on the other hand, I think that that's not really a fact, but it's a controverted issue in the case, I'm going to object. And I need to watch and make certain that the opposing side doesn't try to use judicial notice to remove issues out of controversy that I feel are in controversy in the case. From a criminal perspective, if I'm a criminal defense lawyer, it's very difficult to make an argument to me that I should agree with the court wishing to take judicial notice of a fact, unless it's something that is so accepted within the community or doesn't hurt my theory of the case. Examples might be the name of streets, the locations of buildings, telephone numbers, things like that. On the other hand, if it's something like the time the sun went down or how well someone could see at a particular hour, and that's relevant to my case, I'm not giving that up. My client has a right to force the government to prove it to be beyond a reasonable doubt standard, and I'm going to make them do that unless there's some benefit to my client by agreeing to the judicial notice. So, as we're looking at Federal Rule of Evidence 201, judicial notice, we want to think of it practically from an advocate's perspective. What facts will it help us get into the record so that they won't be in controversy? What impact do those facts have on the way in which we tell the story of our case and ultimately persuasively represent our clients? When it's to our benefit, we use it, and when it's not to our benefit, we oppose it. If you'll do that, you'll be fine. Till next time, this is Practice Ready Evidence with Charlie Rose.